crashes, defective products, dangerous drugs, injuries, and abuse. Across the state of Alabama, the attorneys, proudly sponsored by the law firm of Hollis, Wright, are here to serve you. Your tough legal questions answered by our experts with host David Lamb and the attorneys of Hollis, Wright.
Good evening and welcome into the attorneys. Thank you for joining us tonight. Looking forward to our conversation. Got a fantastic panel of experts to lead us through this conversation, and we have you. So we have everything we need here tonight. So thank you for being a part of it. If during the show tonight you have a question or a comment, we'd love to hear from you. Call, text, email, that information at the bottom of your screen. Also, Hollis Wright makes available attorneys who are standing by live right now, ready to speak with you. So if you get a question, 844-LAW-TALK, that's the number to know. 844-LAW-TALK is the number to know. Josh Wright, he's managing partner of Hollis Wright. 844-LAW-TALK.
Easy for you to say, my friend.
I should know how to say that.
Easy for you to say.
That's the number to know. How you doing, sir?
I'm doing great. How are you doing?
Doing very well.
Everything
Thank
well?
you. Everything's good. Thank you.
Good. Well, you know, David, one of the things that our firm has done since its inception is we've done mass tort litigation in addition to what I call single event litigation. Those two are separated a little bit. Traditional accident, injury, that's kind of a single event based practice. Mass torts is where we'll represent thousands of people at one time in one unified litigation, maybe based in New Orleans or based in Cincinnati or St. Louis, and we'll help manage cases for individuals and litigate those cases. We do both those things. And I do a lot more on the single event side, but we are lucky tonight that Bo Bell, one of our partners, who is one of my favorite people at our law firm because he loves doing things like this so much, don't you, Bo?
Yes.
Yes, he loves this. Bo is one of the heads of our mass tort department, truly does an incredible job. How he manages the mass tort department, I really don't know because it takes a lot of work and a lot of patience, but he's done an outstanding job. So we're glad to have you on.
Well, thank you. Thank you for having me.
Obviously, when we're talking about someone that's an expert in this area, you've been doing this for so long, just start a little bit with kind of what is mass torts and how do you describe that? Because I want to talk about some of the projects our firm's working on right now so the viewing audience has an opportunity to hear about that. But I want to just talk a little bit about your practice group because it's a really unique practice group.
Right. What we do at our firm is, at least for mass torts for me, it's going to be medical device litigation or pharmaceutical litigation. And what makes a mass tort different than, say, like a car wreck case is it's not going to just affect one person. One car wreck is going to affect that person, that is that facts for that person, and that's going to be the only lawsuit. What we do is we'll have a bunch of people call us about a certain product, they've been injured, and there are going to be, thousands of these people. And it's not just our firm. Firms around the country are getting these calls. So these lawsuits started getting filed around the country. And eventually, people start looking around and going, we don't want the same lawsuit being filed in California and Alabama and New York and different judges doing different things and making the defendants do the same thing over and over again. So there's a body called the JPML that people will petition to. Sometimes the defendants ask for it, sometimes the plaintiffs do, and they will pick one federal location for all these cases to eventually go under. And the idea is if you're under one roof, you won't have all these different contradictory orders coming out, and you'll have everyone there, and you'll split. It's also efficient because we start, all the attorneys work together, and we share in the cost of the experts and things like that. So where a case by itself could cost millions of dollars, you can spread that over thousands of people by sharing this information. And the idea, again, get it together, and it's very possible in this setting, after a trial or two, they may be able to resolve them all. Now, if it doesn't, they will go back to where they should have been filed originally, and you would have that one-on individual trial. And I just want to say, a lot of people get confused with mass torts and think it's a class action. And the big difference with class is I don't need thousands of individual lawsuits. In a class action, I really could just have one of you and file that lawsuit, and you would act like the rep for everyone. So what's different here is these are individual lawsuits. I want people always to know that because people call me like, I don't want to be part of the class. Like, this isn't. This is going to be, at the end of the day, your facts are going to matter. We're just all going to be in one location. Yeah. And that's kind of how it works.
And you just hit on a very important point, which is you get a lot of phone calls from individuals to make sure that their case is individualized. You run our entire mass tort department, and it's a big group with a lot of staff members and lawyers. How do you give an individual feel to each client when you may be representing hundreds of clients in one medical device case or thousands in another? How do you give each individual, or how do you explain to them that they're going to get the personal touch that their case matters no different than anybody else's?
Yeah, and it's something I think we pride ourselves on doing. I mean, it is, again, you keep up with the phone calls, you keep the client involved, and you let them know from the beginning, this is how this is going to work. Understand that your facts will matter. This is not, one size fit all. Everybody's not, if it settles, everybody's not getting the same. And I think a lot of people are worried about that. Like, that's not fair, because my injuries may be worse than this person. Like, it will be somewhat individualized. I mean, there are some limitations to that. It would be hard to, sit with every variable for 10,000 people. But I mean, you just try to remind them, this is about you. Your records matter. What happened to you mattered, and we're going to make sure that we get the best, result for you possible. And it's going to be, at the end of the day, I mean, this will be what you should reserve. It's not the global. You're just getting this.
Yeah, you can already tell the bedside manner of a mass tort lawyer is so important, and Bo's got that, and that's why he's the head of our department. And it really is. It's interesting and unique that you may represent 1,000 people at a time, but their individual facts, as Bo mentioned, are so critically important, because just because you're part of a group doesn't mean that you get the benefit of some resolution if the rest of the group resolves. Your individual facts, your individual injury, your individual medical records all matter.
How long have we've done the show for about 10 years, I think, something along that, and I believe you've been around longer than I've been around the show. How long have you been at Hollis, Wright?
I've been there 12 years now, and I would think that would make me second longest tenure attorney at the firm.
Really?
Yeah. And he's done mass torts really from the inception.
Absolutely.
You came in on one of the very first mass tort cases that I recall working on individually, and I kind of managed it with you, and he's done just such a great job. All right, we got some time before we go to the first break. Let's jump into some of the projects that the firm's working on, because I do think that it kind of puts a face and some context to how this process works. Let's talk about Roundup a little bit.
Okay.
Explain a little bit about the Roundup litigation and how that is being managed here at the firm.
Sure. Just some background. Roundup, as you know, is it's a weed killer, and there's a component in it called glyphosate, and that has been determined to cause cancer, specifically non-Hodgkin's lymphoma. And what we've done in our firm, obviously, we've fielded many calls from people who have been exposed to this. And this could be the individual using it in their yard or the large-scale landscaping. And those cases have been filed around the country. There have been some great verdicts on it. Unfortunately, the EPA and the government still says it's safe and everything else, but these juries are looking at this evidence in a trial saying, no, that this does cause, or is a substantial cause of these cancers, and they knew about it, and they failed to warn. And I know that's a quick rundown because we're running out of time in this first segment, but that is kind of how we're handling it.
Yeah, well, we'll spill over into the next segment on this because I do want to finish, but let me ask you this. As it relates to the carcinogen component to it, have different world organizations listed this as a human carcinogen or as a probable human carcinogen?
Yes. In fact, the World Health Organization, the WHO, in 2015 found that it was a substantial carcinogen, and another group, and I apologize, the name has escaped me, also found a specific link between exposure and non-Hodgkin's lymphoma. So it's not something that we've made up. It is something that entities have found to be true.
So one of the things, and I know we're getting ready to go to break, and I want to talk more about Roundup when we come back, but one of the things that's interesting that Bo would be the first to tell you is science matters in these cases, whether it's a medical device, whether it's a drug, whether it's a pharmaceutical product. The reality is that the science matters, and the science is ever developing during the course of this litigation a lot, where there may be a break in the science, good or bad, that impacts the value of people's claims, where Bo, for example, has to educate people on, hey, this has changed. The science has changed. You need to be aware of this. And that's part of the bedside manner that's required of a mass tort guy.
Yeah, and he does it well. All right, Bo, Josh, we're going to be back here in just a minute as we head to our first break. A reminder, Hollis Wright all over social media. So whatever platform you are on, Hollis Wright is on that platform as well. Just check him out. A great educational, informational follow there on your favorite social media platform. Stay tuned. More of The Attorneys coming right up.
I'm Josh Wright with the law firm of Hollis Wright, a personal injury law firm, and thank you for watching The Attorneys. We hope you, a friend, or a loved one never needs legal counsel for a case. But if you do, the goal of the show is simple: to provide answers and legal counsel when you need it the most. Your call to the show is free and off air. So if you have questions specific to the show or related to other accident or injury topics, call, email, or text us. You can also follow us on Facebook, Twitter, Instagram, and YouTube, or go to hollis-wright.com and click on the Contact Us button. We know your time is valuable, so thank you for spending it with us and watching The Attorneys.
The Attorneys, proudly sponsored by the law firm of Hollis Wright, are here to serve you.
When we started the show 8 years ago, my hope was we would be able to do what we do best, which is to help people answer real-world legal-related issues they have in their life.
People oftentimes are confronting various legal issues and problems in their lives that range across the gamut of legal practice areas. Bankruptcy, criminal law, family law, just to name a few. And to be able to have a 30-minute platform or format to where we can just cover various legal topics once a week, that's obviously the primary focus of the show.
That we would be able to use the resources of the many lawyers we have at this law firm to create a plan that had a lasting impact that also gave back to the community at the same time. And I think we've done just that with The Attorneys.
Welcome back in to The Attorneys. Before we get back to the conversation with Josh and Bo, a reminder, if you want to take advantage of the opportunity to speak with the attorneys from Hollis Wright who are standing by live, 844-LAW-TALK, 844-LAW-TALK. That's the number you need to know. Josh?
Bo, let's talk a little bit more about Roundup. As it relates to the litigation, are there other telltale cancers or injuries that people should look for if they use Roundup a lot, or is the non-Hodgkin's lymphoma really the primary one?
I would say the non-Hodgkin's is probably the primary one. There have been other claims, but the experts that have been brought in for this and the way the litigation is going is really focused on that particular type of cancer. Doesn't mean that things can't change in the future and they may be able to link it to something different, but that seems to be the strong point right now.
If someone's sitting on their couch right now, they have non-Hodgkin's lymphoma or they're recovering from that in the past, what do you recommend? How did they get that process started? They simply make a call and you'll evaluate the case? How does that work?
And that is exactly true. You call us, we're going to ask you a few questions that we want to know, especially, your type of exposure, when you were exposed, when you were diagnosed, things of that nature. And that's how it starts the process, whether it's our firm or anywhere else, is making that phone call and ask it.
Do you have to have evidence that you actually purchased Roundup from a Home Depot or somewhere else, or how does that work?
And that's really going to be a tough one. I mean, obviously, if you still have receipts or, you still have it in your house, certainly, but it's going to be word of mouth for the most part. I mean, certain occupations are going to be, that makes sense. Lawns, landscaping, things like that. But that's going to be a problem for anybody. I mean, and so far it's really been, you attesting to the fact that you were around this product and whether that attestment is believable.
Is Roundup still available?
Yes.
Wow.
Yes, still on the market.
Yeah, the government and it's Bayer now that owns Monsanto. Their position is there's nothing wrong. Even after court losses, the EPA still is out there saying this is a fine product. It doesn't cause anything. So it's definitely out there, and I don't know if they'll ever change their opinion on that. But these lawsuits are starting to come down, and the verdict's been pretty high. So. Yeah.
Let's talk a little bit about another project our firm's working on right now, hernia mesh.
Okay.
Tell us a little bit about hernia mesh and how someone would have hernia mesh even installed in their body, why it's installed, what type of injuries they can have, those types of things.
All right, that's a lot.
I know. I just threw a lot at you
Okay.
to allow you to talk for a little bit.
You would get a hernia mesh because the doctors decided that you have a hernia that needs to be repaired. There are different ways you can repair a hernia. You don't have to use mesh. You can use sutures. You can use your own fascia and things of that nature, but hernia meshes are very popular. And they're very popular because the companies have really convinced these doctors that you will have less chance of recurrence if you use this mesh. If you don't know, recurrence means that you repair the hernia and then all of a sudden it comes back. What we're finding is that the recurrence rate between using sutures, which we believe to be really safe, versus using mesh is about the same. And the problem is the hernia mesh has way more potential complications. So that's kind of where our case is about. These products are made out of polypropylene, which is basically a plastic, almost like fishing line. And studies have shown that this product will degrade and it will also shrink, and that can cause all sorts of problems when it's put inside you. Also, another issue with hernia mesh is recently, I want to say 6, 7, 8 years ago, these companies knew that these things were degrading in the body and they were attaching themselves to other organs, so they came up with what they called composite mesh. And they just put a film on this mesh. I think one company used fish oil. It's just kind of random stuff on there, and they told doctors this will be a barrier. This will stop this from happening. But the FDA heard that and said, no, you cannot call this a barrier unless you're going to willing to do really stringent clinical trials. So the companies, did they change their mind? No, they just said, we'll stop calling a barrier, but here you go anyways. Right. And these things became very, very popular. And that's probably, we were looking at both types of mesh, composite versus non-composite, but the majority of our cases are this composite mesh because these things, again, they did not stop recurrence, and they're causing all sorts of issues. I mean, they're eroding into the bowel, they're migrating. They're forming what's called a meschoma. That's a term that came up solely for this product because it will ball up and harden like a tumor. So that is the basis of our cases. I know you asked me a lot of questions. I'm not sure if I caught them all.
No, that's good. I mean, how does someone find out? Let's assume, they're like, hey, look, I think I have that product. How do they find out what type of product they have in their body?
The only way really to do it is to get the medical records from the hospital where it was put in. Okay. Every time the hospital puts a device in your body, they're going to take a sticker, almost like off the box, and stick it on the records. And it's going to have the lot number, the catalog number. It's going to say who the manufacturer is and what model you have. Okay. And that is, we call that the product ID sticker or the sticker page. When I order records, that's the words I put on there. I don't want 1,000 pages. I just want to know what that sticker says at first. So, the client certainly can do that, but if they have concerns, they come to a firm like ours, we do that for you. We find out what you had and try to determine which product it is and whether there's a path to compensation with.
Hey, we do these cases on a contingency fee too. So someone can come to us at no cost. We order the medical records for them at no cost. And the reality is we'll evaluate the medical records, determine even if they fall within one of the meshes that is manufactured by a company that's subject to a recall. We do that regularly.
Absolutely. All our cases are on contingency. So even at the front end, if I just order a record, turns out you have a mesh that I'm not pursuing, or it turns out it wasn't a mesh, or it was something other product, that doesn't cost you anything. And that even goes further to the point where I take your case, I file it, I spend money on it, and at the end of the day, unfortunately, it ends up as a zero case. You don't pay us anything. That is something that we take on. We looked at it, we evaluated it, we thought it was strong enough to take it, so the risk, you don't have any. Yeah. We do it for you.
Yeah. You can tell Bo's passionate about this stuff, which is good.
He is. Bo can also cover a lot of ground real quick, too.
Well, and I can throw a lot at him, and he's able to spit it back.
Yeah.
He does this at meetings at the firm all the time, don't you worry. I'll just throw it all out there, and boom,
he'll just let it anymore.
Yeah, you didn't seem freaked out by it. You handled it, yeah.
No, it's I talked a little bit about the bedside manner component to a mass tort lawyer. It's unique and different because I may be talking with a personal injury client, on a weekly basis, and that's just commonplace, right? They're used to texting me or, sending me an email and getting a response, or calling me and wanting something or needing something and needing to provide us information. Bo's doing that at this gigantic scale, and it's why he has this big staff that he's got to train to make sure they understand the importance of individualizing all these clients. Mm-hmm. And it's complicated. It really is. And we've done it for 20 years, and Bo's done it at our firm for a very long time, and it's just complicated. So, I always have a lot of respect for the guys that are in the mass tort department because they really have to work on their bedside manner as such an important component to the success.
After the break, what do you want to get into?
I want to talk about 3M. That's another project that's fairly recent. Bo's really involved in that right now, and I want to talk about that because we've got a lot of 3M clients, and I want him to explain what's going on with the 3M earplugs and what that litigation is all about.
Hearing a whole lot about that. We'll get into that after the break. Stay tuned. More of the attorneys coming right up.
I'm Josh Wright with the law firm of Hollis, Wright. In court, attorneys are not allowed to tell juries certain things. For example, we cannot talk about a defendant's net worth, meaning the defendant's ability, resources, or insurance to pay a verdict. In this week's Legal 4-in-1, we're answering the question, why can't lawyers talk about a defendant's net worth to a jury? Now, Rule 403 of the Alabama Rules of Evidence states, in part, relevant evidence may be excluded if its probative value is substantially outweighed by the danger of unfair prejudice. Long-standing Alabama cases have held that the net worth of a defendant falls under this catch-all rule and is to be excluded. The reasoning behind the rule is that if a jury knows a defendant is wealthy, then the jury might award more money to the plaintiff. And this goes one step further. If an attorney makes any remarks that suggest the defendant is responsible because he is wealthy or rich and the plaintiff is poor, that can be grounds for a new trial. If you're ever on a jury, the reality in our state is this. In almost every lawsuit that goes to trial, the attorneys representing both the plaintiff and the defendant have already looked at whether there's sufficient insurance coverage or assets to satisfy a verdict. Most likely, the parties would not pursue a civil lawsuit if damages could not be paid after a jury returns a verdict. So even though lawyers cannot mention the net worth of a defendant during trial, there likely are resources available to pay a verdict in court. Please remember, your call, email, or text to the attorneys is free. All of us at Hollis Wright want to help answer your questions on real issues you face. And remember, a competent lawyer will respond to every question you send in. That's our pledge and promise to you. And as always, thanks for watching The Attorneys right here on WVTN 13.
Welcome back in to The Attorneys. Just a few minutes remaining, a little over 5 minutes remaining in the show tonight. And why that's important to you is if you would like to speak with those attorneys from Hollis Wright who are standing by live to speak with you, that free, all-fair, confidential conversation at 844-LAW-TALK. You got about 5 minutes to take advantage of that opportunity. Josh?
All right, so when we went to break, Bo, I mentioned that we're involved in a new litigation, which is the 3M earplug litigation. Let's take it kind of one step at a time. As far as the litigation goes, explain what the 3M litigation itself is.
Okay. 3M litigation is about a dual-sided earplug manufactured by 3M. These were given to our service members to protect their ears. There was two sides. One side is supposed to stop all sound. The other side is supposed to let some sound in, mainly voice control. So when they're on the battlefield, it blocks out the big impulse noises, but you still can hear your commands. The problem is this product didn't work. And they fudged their own science on it. It was supposed to have a noise reduction rating, and not this will matter anything to the general public, but it was like 22. And when they finally went back and tested it, it was 10. So it really didn't even come close to meeting the standard to protect our military members' ears. The other issue we're looking at in this litigation is we are pointing at the fact that we think it's a design defect as well. So never mind that it didn't work, but it wouldn't fit in the ear properly. It was too short, therefore it didn't stop the sound, or it was very prone to loosening. So that's kind of what we're talking about when we talk about 3M dual-sided earplugs. And they were the only dual-sided earplugs out there. And that's basically the brief version of it.
And so were they issued by the U.S. government to these service members?
Yes. The government made a deal with 3M to supply these dual-sided earplugs that they lied about how well they worked. So if you were in the military between 2003 and 2015 and you wore a dual-sided earplug, that is going to be a 3M dual-sided earplug.
And so how are these cases evaluated? Are you looking for a telltale, injury to the ear, an auditory injury, and what are you looking for?
Exactly right. First of all, we want to make sure that you were in the military during the time, and that you are claiming you use these dual-sided earplugs, of course. But we're looking for hearing loss, and that can range from minimal to extreme, and then tinnitus, which is that constant ringing in your ear. And some of our service members say that's the worst, because that constant ringing can lead to all sorts of health psychological issues too. I mean, the depression and just anxiety. And it's interesting to note that tinnitus is one of the #1 reasons that you get disability when you're in the military. And that's kind of the main injuries.
Gotcha. This is one of the larger litigations we've really even been a part of in the past. There is such a significant number of military folks that fall within this long time frame of 2003 to 2015. It's just a really large litigation.
Yeah, that's a long time.
Yep.
It is. And I would say that the public didn't even know this existed until July of 2018. Because the Department of Justice sued 3M. There was a whistleblower lawsuit saying they fudged this data. They sold you defective products. And under a federal statute, they sued 3M. This was all hush-hush quiet. It wasn't until July 2018 that it was finally announced that 3M had to pay the military or the government $9.1 million. And that's when the general public started, finding out about this. And that's really when these cases started picking up, and they continue to pick up steam.
Are some of these cases filed nationally?
They are all now centralized in Florida, in northern Florida. The judge herself is a former veteran. So talking about what I said about mass torts, it doesn't matter where you file it, it's going to go there under her purview to handle these matters.
I bet 3M loves that a former military person is
Yeah.
be the judge. A minute and a half remaining. I want to give both of you the opportunity for a final thought. Bo, if you would, you go first.
Sure. These cases we're talking about are the ones that are the most populous right now in our firm. Next time I'm on, I suspect there'll be more. So if you think that you've been injured by a medical device or a pharmaceutical drug, please contact us or check our website to see if there's any new projects that are on there before I make it on here again. And that's what I would tell you. Always reach out, talk to an attorney. They can tell you whether they're accepting it or they may know someone else. Even if they're not doing it, they may be able to pass it on to another firm who is.
And you mention a lot, David, that we have a social media presence, whether it's Instagram or Facebook, and Melissa in our office does a great job of promoting the litigation that we're looking at. So sometimes just following us will give you an indication of some of the new projects that we're working on. And it may never fit for you, but you know what? It may fit for a neighbor or a family member or a friend. And so following us on social media gives you a leg up to know about some of this litigation from a mass tort perspective. But, if nothing else, I wanted to make sure we brought Bo on today because Bo does such a great job of being able to manage the mass tort department. It's not an easy department to manage. So we're super happy to have him and glad we're able to go through a couple of our projects.
Bo, good to see you.
You too.
Thanks so much, Josh. Good to see you as well.
You too.
All right, we're wrapping it up here, but we're going to be back next week. Hopefully you'll be back with us. We thank you for joining us as always, and we'll see you next time right here on The Attorneys.
Thanks for watching The Attorneys, sponsored by Hollis Wright.